I talked to her. Okay, have her come in for 1 sec, please. Harold's Chicken. They have sweet potato tater tots.
That sounds good.
That sounds good.
That sounds really good.
A lot of fish. Hey, Ms. Bernard, we're not on the record anymore. I just wanted to make sure I understood what was going on. You want to take a break and you want a chance to talk with Ms. Cabrera a little more about the case. Is that right?
Yes.
Okay. Since she's in trial, what I'm going to do is we're going to keep your case on this trial calendar because Ms. Cabrera might finish early enough, not today, not tomorrow, but in the next few days, that she could still connect with you during this trial calendar. But if not, you'll be back on the August trial calendar, which is only about a month away. So you need to come back here for that. And you're always welcome to have a trial. You've got an absolute right for the jury to hear all about what was going on. You'd be the only one going to trial. Mr. Martin has pled, Mr. Ross has resolved the case. We'll bring you back at the latest for that August calendar. But we could just do what we did today, but finish it all the way through, whether it's an offered plea or whatever you and Ms. Cabrera sort out, okay?
Okay.
Does Ms. Cabrera have a good phone number for you now?
Yes.
Okay, well, Ms. Bumpus does. She'll get that to Ms. Cabrera. Do you have any questions for me?
No.
Okay, well, I appreciate you staying here all day. I know that was a lot of waiting around. I had thought you were ready to go forward, but you need to be ready to go all the way through. And if you're not, then we'll see you soon. Who did you bring with you?
Who is he? Who is he to you?
Her fiance.
Her fiance.
Okay, great. All right, well, maybe he'll be with you when you come back, all right?
Okay.
Take care.
Thank you.
You gotta ask, because I almost said, is that your dad?
I did too.
But I didn't.
Glad you asked.
Yep, because I've learned it's not Coolio.
It's definitely not Coolio.
Cash app. All right, if you can come on up again, Ms. Bumpus, we'll see if we get through with Mr. Palmer. Mr. Palmer, you ready?
Yes, sir.
We're gonna get on the record in your two cases. You are position 6 and 7 back to back. I won't read the numbers, they'll be on the docket. You are, for purposes of your plea hearing, being represented by Ms. Bumpus, who is a friend and colleague of Ms. Cabrera's. And I want to make sure you're okay having Ms. Bumpus standing by your side instead of Ms. Cabrera for the plea.
Yes, sir.
Yes, okay. Ms. Davis is going to put you under oath in just a moment, ask you a bunch of questions. You need to answer those verbally so we can hear you and truthfully. But I also need you to let me or Ms. Bumpus know if you've got questions of your own. Will you do that?
Yes, sir. I will.
Excellent. And we're in a good spot. Ms. Davis?
Please raise your right hand. Do you swear or affirm the testimony you will give in the matter before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Excuse me, Judge. I'm sorry. Can I sit down until it's my turn?
You sure can.
Thank you.
You can put now that you've been sworn in, you can put your hand down. The fact that Ms. Bumpus is sitting is good for her. She should be sitting. But if you need to talk with her, just walk right back there and talk with her. She's not abandoning you. Okay?
Yes, sir.
All right.
Okay. Please state your true, correct, and legal name for the record.
Corbina Omar Winston Palmer.
Okay, I'm gonna ask you to spell your first and then your middle name for the record.
Yes, ma'am. Corbina is Kwabena.
Okay, and your middle name?
Winston, Winston.
I had an Omar down here.
Omar and Winston.
Oh, you have two middle names.
Okay.
Which comes first, Winston or Omar?
Omar comes first.
Okay. And then Winston and then Palmer.
Yes, sir.
All right. It's a long name.
Are you at this time under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
At 38, I got my GED, college equivalent.
And what was the last part?
It was the college equivalent course when they changed it.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offenses? In indictment 23 SC 191639, you are charged with possession of a drug-related object, giving a false name, address, or birth date to a law enforcement officer, driving on a suspended or revoked license, and possession of a firearm by a convicted felon.
Can you repeat the first one? I didn't get the first one correctly.
Drug objects.
I
It's
didn't
just
know
an
that.
object that's used to,
It would be as simple as like a crack pipe is a drug-related object, or scales that are used to weigh drugs could be a drug-related object.
No, I didn't know. I think I got charged with that crime. That's
Do
what I
you
was
need to
saying.
see the indictment?
Yeah, I ain't seen nothing on my paperwork.
Okay. I can't do this. I need the indictment.
I have a copy. Yeah. Let me just triple check what the object was. You can have this. Oh, it was a scale.
No, I don't got no discovery, nothing.
So then why you taking free?
Because I know my record is not gonna look good. Period. If I even try to take it to trial, I got a long distance of record. I ain't trying to go into detail. She claimed that they still charged me with the charge. I thought initially supposed to get trial, but they didn't even do that. He just charged me just because I was there. And I know if I take that to trial, I'm not.
The second indictment.
They gonna go off my history.
Okay. You don't even want to look at it?
I mean, I did, but at the time, everything I pushed back. And like I said, I don't want to take it to trial. I'm trying to negotiate the situation. Period. 'Cause
Okay, just 1 second. I can't do this. I don't feel comfortable.
Okay.
Okay.
I can't do it.
No, you are technically capable of doing it, but I heard what you heard, which is Mr. Palmer saying it's the first time he saw the indictment.
And you've never seen this stuff.
Okay.
So, I mean, that's what he's saying. I don't know if that's the truth.
I don't know. I haven't been part of the Cabrera Palmer communication flow. But what we need to do, Mr. Palmer, is make sure you and Ms. Cabrera have a chance to sit down face to face. She shows you what's in the state's file. You're more familiar with the charges. I'm assuming you got arrested for this stuff, so you are remembering the incident. You and Ms. Britton must have been, I don't know if you were in a car or what, and there was stuff in the car, and you're charged with parts of it. She's charged with other parts. You're not charged with the gun. She is. So I don't know if it was like in her purse and not your bag, but we won't need to get into that. We need to make sure you and Ms. Cabrera have a chance to talk. So I think I'm going to do, just so that the cases move along together, since you and Ms. Britton are co-defendants on one of the cases, is that I'll just move your cases to the September trial calendar.
Yes, sir.
Means you need to come back here. More importantly, you're going to need to connect with Ms. Cabrera before you come back here. And partly that's on your lawyer, but partly that's on you. She's busy, you're busy. You're the one who needs to sit down and talk with her. She knows what your case is about. She could come in here and say, hey, you know, there was a confession, or it's on video, or whatever the situation is. Do you have her phone number?
Yes, sir. And to state, it's not that bad communication, nothing. It's every time I call her, she's been in trial. So
Got it. Okay. I figured as you saw your trial date coming up, you're like, hey, we need to talk.
Yeah.
And she's probably saying, I'm stuck in trial. So then the right thing to do is for us to try this again. If you and Ms. Cabrera conclude that a plea is the right answer, same offer will stay open? Sure. Okay. All right. So Ms. Cabrera knows what the offer is. It's whatever you talked about, either with her or with Ms. Bumpus. And we'll just see what happens at the September trial calendar. Okay. Any questions?
No, sir.
Okay. See you around. Oh, I've got a question for you. Tell me your connection to Ms. Britton.
All right. So when I first met her, she done got put out the house when her friends that had passed away. So she the house she was at, she lost it. So everybody like put her out and everything. So she was in a hard situation. So I know me, I got a ministry and everything. I done started up since I've been home. So I let her come, and she was doing one of the past splits in the open houses. So, when her friend died on the 10th of July of 24, I think it was, or 23, we went over there to the candlelight vigil. And I can't really say anymore because it goes into my case.
Okay, and I didn't mean to ask you about the case, but you two, you know each other.
Yeah, that's it. She was when I met her, just like I'm helping her out, you know what I mean?
Yeah, okay. But you guys know each other. You're not related. She's not your cousin or anything like that. Okay, got it. All right. Well, we'll see you at the latest for the September trial calendar.
Yes, sir.
Thank you.
Well, that took a turn. The plea hearing for Corbina Winston Palmer was heading for a quick resolution until it suddenly wasn't. What started as a standard, even laid back, entry into a negotiated plea turned into a lesson in why full preparation matters, especially when you're the one taking the weight. Mr. Palmer, 38, appeared in court alongside a stand-in attorney, Miss Bumpus, due to his primary counsel, Miss Cabrera, being tied up in another trial. Things moved swiftly through the usual checkboxes: name, age, education, citizenship, understanding of charges. But the moment the state began listing off the charges, including possession of a drug-related object, Palmer hit the brakes. Right away, he was confused. "I didn't know I got charged with that," he said. "That's not on my paperwork." You could feel the air shift. This wasn't a case of someone playing games or pretending to be surprised. It seemed genuine. He explained he hadn't received any discovery and didn't know all the details of the indictment. That's when the judge called it. "I can't do this," he said firmly, but with care. The proceeding paused, not because Palmer was unwilling to plead, but because no one was comfortable having him do so without fully understanding the charges. In other words, the system hit the brakes for the right reasons. Palmer was transparent about his motivation. He knew his criminal history was extensive, and he expressed a real concern about how that would affect a jury. He believed a trial wouldn't go his way regardless of the fact Sand was trying to negotiate, not because he was eager to admit guilt, but because he felt trapped. That's heavy, and it's not uncommon. But the court wasn't willing to accept a plea simply because someone felt they had no other choice. That's how it should be. The hearing was paused and the case was bumped to the September trial calendar, giving Palmer and Miss Cabrera a chance to meet, review the discovery, and make a fully informed decision. And the judge reminded Palmer that while his lawyer had obligations, so did he. "You're the one who needs to sit down and talk with her," he said. The offer on the table will still be there, but the next steps require clarity and communication. Before wrapping, the judge asked Palmer about his co-defendant, Miss Britton, and the backstory revealed another layer. Palmer explained that she'd been in a vulnerable spot-lost housing after a friend passed stand. He was helping her out through a ministry he'd started since his own release. It was a rare moment of personal context that reminded everyone that the courtroom isn't just about case, it's about people and the stories behind the docket numbers. This hearing showed how important it is for defendants to feel seen, heard, and fully informed before making life-changing decisions. It also showed a judge willing to pause when the system moved too fast. In a justice process that often feels like a conveyor belt, this was a reminder that sometimes stopping is the most just thing to do. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.